Today, me and my group will be presenting about fiduciary duties of directors. My name is Muhammad Adam Daniel bin Zahari, UDE 220188, and the fiduciary duties cover the duty of trust and confidence between parties and stem from the common law duties over the years. And most of these are now codified under company legislation. In addition, it is directors who are the ones that owe a fiduciary duty to the company. Moreover, a director is an individual entrusted with the management of a company's business affairs. I will begin by explaining the definition of director's duty to act bona fide in the best interest of the company. This duty emphasizes how the directors must exercise their powers for a proper purpose and in good faith in the best interest of the company. This means that the directors should act honestly, transparently, and with loyalty to the company. In other words, directors must exercise their powers in good faith in what they consider and not what the court may consider to be in the best interest of the company and not for any collateral purposes. The directors must also reasonably believe that the business judgment is in the best interest of the company. This requires a balance between the subjective belief of the director and an objective assessment of the company's needs. Directors should not have a material personal interest in the subject matter of the business judgment. This ensures that the decisions are made objectively. And lastly, directors are expected to exercise a standard of knowledge, skill, and experience that may reasonably be expected from other directors. That's all for my part. I'll pass it to the next presenter.
Thank you, Adam. My name is NURUL IZZATI binti ASRIN, and my matrix number is UDE 220175. Now that we have grasped the essence of duty to act bona fide in the best interest of the company, let's delve into a couple of pertinent case laws that shed light on this crucial principle. Firstly, the case law of Board of Trustee of the Sabah Foundation and 2 Ors versus Dato Sheikh Kecil bin Sheikh Mohammed and Anwar 2008 5 MLJ 469 serves as a stark reminder of the consequences of breaching fiduciary duty. Here, the federal court emphasized the obligation for directors to act in good faith and for the benefit of the company. The subsequent Banita appeal highlighted the repercussion when this duty is violated, as Dato Sheikh Kecil was found liable for breaching fiduciary duty and required to disgorge any profit made through such breaches. This directly correlates with the duty to act bona fide, as directors are expected to prioritize the company welfare above their own. Similarly, Percival v. Wright underscored the fiduciary responsibility directors owe to the company rather than individual shareholder. Despite not disclosing inside information during the sale of shares to individual shareholder, the courts ruled that the director action were aligned with their duty to the company, reinforcing the principle of acting in good faith for the company's best interests. This duty, grounded in the principle of acting bona fide, highlights the director's obligation to prioritize the company interests even in transactions involving shareholders. These cases emphasize the pivotal role of the duty to act bona fide, the paramount importance of director fidelity to the company's best interests, as well as highlighting the legal ramification of failing to uphold this duty.
Hello, my name is Godzusing and my matrix number is UDE 220072. Now I will describe about the fiduciary duty of director not to act for an improper purpose. This duty states that a director must exercise his power for a proper purpose and a good fair in the best interest of the company. This principle ensures that the director might use their power to eliminate the business objectives that align with the company goal and benefit the shareholders and the stakeholders that cannot use their authority to benefit themselves or any other party of the company expense. They are expected to act honest, with integrity, and with a silent belief their actions are in the best interest of the company. This involves prioritizing the company welfare above the personal gains of the interest or any other parties, focusing on enhancing the company value and ensuring the long-term success. So, adhering to this duty is significant for several reasons. Firstly, it helps build and maintain trust among the shareholder, employee, and other stakeholders, which is essential for the company reputation and smooth operation. Secondly, it prevents the director from using their position to pursue their personal agenda, thereby safeguarding the company from potential harm caused by conflict of interest. Lastly, it promotes the fairness and transparency in corporate decisions, contributing to a positive business environment. By upholding this duty not to act for an improper purpose, directors ensure that their action to foster the trust, integrity, and overall success of the company. In conclusion, the duty not to act for an improper purpose is a constituent of effective corporate governance. It maintains that the director act ethically and prioritizing the company's best interests, ultimately contributing to the company's success and sustainability. Now I will pass to ALYA.
Thank you, Sandy. Assalamualaikum. My name is NABILA binti NORAZAM, matrix number UDE 220111. Now I will give a two case related to duty not to act for an improper purpose. The first case is about Advanced Bank Australia Limited versus FAI Insurance Limited. The legal dispute revolved around the interpretation and responsibility for indemnity costs in the contract between Advanced Bank and FAI Insurance Limited. Advanced Bank claimed that FAI failed to meet its contractual obligation, resulting in financing losses for which there sought indemnification. So the court decision is this case is that FAI Insurance Limited was found liable for breaching its contractual obligation to Advanced Bank Australia Limited. As a result, FAI was ordered to indemnify Advanced Bank for the financing losses incurred due to the breach. The second case is about Tengku Dato Ibrahim Petra bin Tengku Indra Perita versus Petra Perdana Berhad. This case more focused on corporate governance and the management of the company, especially concerning the sale of share in Petra Energy Berhad (PEB), a subsidiary of Petra Perdana Berhad (PPB. The director of PPB sold PEB share, which were considered high valuable to PPB, to Software Resources Sdn Berhad, leading to a loss control in PEB. PBB alleged the director breached their duty to act in the best interest of the company. So the court decision highlighted the division of power between director and shareholder and established the appropriate test for determining if a director has acted in the best interest of the company, applying the business judgment rule. The federal court ruling in this case clarified the law regarding corporate governance and the management of a company. That's all. Thank you.
Thank you, ALYA. My name is SYAZA Jahiza binti Jameli with matrix number UDE 220170. Today, I will explain about duty retained discretion. What is duty retained discretion? It is specifically to the world of business and particularly for those in leadership roles like board member or directors. It is a concept that ensures they retain the ability to make independent decisions that are truly in the best interest of the company. Let me show some of the breakdown of duty retained discretion. Firstly, it is an independent decision making that directors have a responsibility to use their own judgment and expertise when making choice for the company. They shouldn't be pressured or obligated to blindly follow the instruction of others. Secondly, it is a flexibility for future situation. The circumstance can change and directors need to be able to adapt their approach based on what's best for the company at that time. Pre-committing to a specific course of action without considering future possibilities could be a breach of this duty.
My name is NURZAFRAN by AHMAD UDE 220138. So next I will explain the case law that related to fiduciary duty to retain discretion. The first one is Bilkar Accessories M Sdn Berhad versus Gordon Toh Chontok. In Bilkar Accessories M Sdn Berhad versus Gordon Toh Chontok, directors appointed by an undischarged bankrupt prioritize the bankrupt interest over the company's breaching their duty. The court highlighted their failure to act independently as required by the Companies Act 2016, emphasizing the need for directors to act in the company's best interest and make unbiased decisions. The next one is Brazilian Rubber Plantation versus Estates Ltd. A major Brazilian rubber company faced financial hardship due to bad investment. Despite the directors' lack of experience and the risky choices they made, the court ruled in their favor. The case clarified that directors are liable for negligence, not simply poor business decisions, and are expected to act with reasonable, not exceptional skill and care. While the Brazilian rubber company's financial woes stemmed from risky investment made by inexperienced directors, the court ruled they weren't negligent, highlighting directors are liable for careless action, not simply poor business judgment. That's all from me.
Hi, my name is FARHANA with matrix number UDE 220186. Now I will explain about the last fiduciary duty, which is duty to avoid conflict of interest. Directors must avoid situations where their personal interests may conflict with the interests of the company. This duty extends to both direct and indirect conflict of interest, including situations where a director or their family members have a financial interest in a transaction or decision made by the company. Directors are required to disclose any conflict of interest and abstain from participating in related decision-making process. Conflict of interest can be defined as the situation where a person who has a duty to exercise judgment for the benefit of another has an interest that tends to interfere with the proper exercise of his discretion. The emerging interdisciplinary theory of conflict of interest shows that personal or extraneous interests interfere with a decision maker's judgment in unpredictable ways, and despite the decision maker's honest efforts to keep them aside. In conclusion, fiduciary duties of directors to avoid conflict of interest are essential for promoting ethical conduct, ensuring accountability, protecting shareholder value, and safeguarding the interests of shareholders. Directors who breach these duties may face legal liabilities and regulatory sanctions. By upholding these duties, directors contribute to the effective governance of the company and help create an environment of trust and integrity in the corporate sector.
Thank you, Farhana. My name is HUSNINA binti Muhammad ARIFF and my matric number UDE 220155. I will explain two example cases of duty to avoid conflict of interest. Firstly, the case of Aberdeen Railway Company versus Blaikie Brothers. A director of a company like Thomas Blaikie in the Aberdeen Railway case cannot be involved in business dealings where they have a personal stake. This creates a conflict of interest as a director might prioritize their own gain over the company's benefit. The court rules such contracts can be voided to protect the company to ensure directors act in its best interest. Secondly, the case of Chua Boon Chin versus JM McCormack and Ors is a landmark case regarding the removal of liquidators in Malaysia. The court ruled that a liquidator, Chua Boon Chin, could be removed if he disregards the wishes of creditors and shareholders of the insolvent company. This case highlights the importance of a liquidator acting impartially and in the best interest of all parties involved in the liquidation process. That's all.
Thank you everyone for your insights. After all those explanations and case law examples, we can conclude that directors are entrusted with critical role in ensuring the success and well-being of a company. Fiduciary duties serve as the foundation for the responsibility, requiring the directors to prioritize the company interests above their own. Adherence to these fiduciary duties not only foster a culture of ethical conduct, but also underpins the stability and sustainability of companies, contributing to their long-term success and prosperity. So that's all from us.